Hi, everybody. Welcome back to Chalk and Gavel. We've got a special episode for you today. As we've mentioned on the show a couple of times, we were at South by Southwest EDU back in March 2026 to record a live episode there. So we're going to bring you that episode today in just a few minutes. Just a little heads up, though, they only recorded audio, so no video on that one, which is
unfortunate.
Probably,
you don't get to look at our beautiful faces.
Yeah, it's much better for you. Trust me. I mean, if you're only listening to this in the car and on iTunes or something like that, you're lucky. But if you usually tune in on YouTube, you're not going to see much. The other thing, what this episode is about, right? It's not a very traditional episode.
Right.
We're not covering a particular court case in this one, right, Chris?
No, we zoomed out. We took the big picture to kind of trace the lines of what we called the education law sea change, or just, how is all of this changing over the last couple of years? We've been covering so much in so many bell ringers, and, the landscape itself seems to be shifting. So we zoomed out a bit to kind of cover the big picture, as well as some strategies for folks who are engaged with this and who want to be more legally literate, or who want to, take an active role in navigating and maybe even
understanding and navigating
and maybe correcting the direction that all of this is going. Right.
So that's what we're going to talk about today, or that's what we talked about when we were at South by Southwest EDU. So without further ado, we're going to bring you that episode. And once you're finished listening to it, please feel free to go to our website and check out our merch and go on your various podcast platforms and give us a like and a thumbs up and a rating and all that stuff, and consider supporting our show as well.
chalkandgavel.com. We look forward to hearing from you, and we hope you enjoy the episode.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
Hi, everybody. My name is Jamie Cudlitz. Thank you so much for joining us today. I am a professor of education leadership at University of North Carolina at Charlotte. And before that, I was a middle school math teacher and principal. When I started teaching educational leadership courses to aspiring school leaders, I had to start teaching the education law courses.
And by had to, he meant he got to.
No, I was very nervous. I didn't really know much about school law. I wasn't a lawyer. Nobody's perfect, I guess.
We try not to hold that against you.
But I got kind of into it. I really enjoyed it. It all seemed really, really important. And it seemed like educators really needed to know about this stuff. So I started doing a lot of research. I started going to education law conferences. They are a lot more fun than it sounds. And that's where I met Chris.
Hi, everyone. I'm Chris Thomas. I am an attorney, though I'm not your attorney. And I practiced school law. I represented school districts. Before that, I was a high school English teacher. Now I'm also a professor of educational leadership and policy at the University of Florida. And when Jamie and I met, we kind of got to talking about how important and crucial education law is, and also how a lot of people view it as something that's kind of scary or intimidating, something that, it's a monster lurking in the shadows.
Right.
Ready to catch you unaware. And so we set out to make this little side project, Chalk and Gavel.
Yeah, and because everybody's got a podcast, so why shouldn't we? So we started this thing just about 2.5 years ago, and our goal with Chalk and Gavel is to tell the stories about how the law shapes education, because the law is so incredibly deeply embedded in how our schools function on a daily basis. So normally our episodes take a deep dive into one particular case, but today we're going to zoom out to look at the legal trends in education. Because, as you are seeing with all these headlines cycling through there's a lot going on right now. So all of these headlines, it's just a lot to absorb. So that's why we do this podcast.
It is. It sometimes feels like we're drinking from a fire hose. But all of those headlines, all of these things going on, like religious charter schools, parental rights, LGBT curriculum bans, like all of those have legal connections. And they all address questions that the law has been grappling with for decades. So while, we might not have the answers, this is familiar ground in a lot of ways.
Yeah, and even though we don't have those answers, we do have a lot of the tools, okay? So the law has given us a pretty good roadmap to help us navigate these kinds of uncharted waters that we're in right now. But before we pull out that map, we kind of need to get a sense of where all of this started and how far these waters have actually risen. So let's take a step back for a second, and everybody in here, think about what school felt like to you not that long ago. Maybe you're a teacher, maybe you're a parent, maybe a student. There was stuff that you learned, right? There were activities that you did. There were books that you read. There was stuff on the walls.
If you're in Louisiana, that might be the 10 Commandments now.
That is true. We'll get there. Don't get ahead of yourself.
Myself.
But whether you love school or you didn't care much for it, there was a shape to what it was, right? And for the most part, we all kind of knew what to expect.
Right, and that shape is changing, and it's changing pretty rapidly. All of these things are all happening at once. And on Chalk and Gavel, we like to think of the law, or sometimes we talk about the law as architecture. It shapes the foundations of education. It's not something that happens out there. It's something that is constitutive of our experiences and what happens on a daily basis in schools. So as the law shifts, so does kind of the educational landscape.
Okay, so let's talk about a few examples that are occurring in this landscape. So while these are kind of hypotheticals, if you've got any connection to schools right now, this is probably going to sound pretty familiar. So you've got a librarian who has to box up books because somebody somewhere said that they were inappropriate. Or there's a history teacher who's trying to teach about the civil rights movement in the 1960s, and they get nervous and they self-censor because they're scared about what they can say or what they can't say, and so then they avoid the opportunity for some really good teachable moments. Or there's a school counselor who doesn't know how to respond when a student comes and shares some pretty deeply personal information. These and so many other legally informed kinds of situations are playing out all over the country in all of our schools on a daily basis. And none of these people are looking for a legal battle, but the law is impacting their lives and their experience on a daily basis and in ways that are changing the shape of schools and kind of remaking those norms and those expectations that we had been so familiar with for so many years. And so that's kind of what makes this moment pretty different. And look, schools have always been complicated. Schools are where society works out its biggest issues. But right now, the speed and the scale of that change is pretty crazy. It's not one law or one case. It's a wave of legislation, litigation, and executive action that seems to be fundamentally renegotiating the rules that govern what school and learning actually is and who it's for. So we came to South by Southwest EDU for the first time, and we're very happy to be here because we know that this is a group that cares about innovation, equity, and about what education has the potential to be. We can't build a future for education on a foundation that we don't understand and is shifting under our feet. If we're designing tools for teachers who don't know what they can say, or curriculum for districts that are navigating these book removal orders, or we're trying to design platforms for students whose legal rights are actively being litigated right now, that legal landscape isn't background noise. It's the daily reality in schools. So yeah, we kind of think this is a big deal. and not in some abstract policy-making kind of way, in a real kids, real teachers, and real communities kind of way. But the good news is we're not the first people trying to navigate these waters, or the best or the brightest, thankfully. These questions about what school should be and who it should be for have been asked many times before, and the law has answered. But the old answers may not be the new answers. So, Chris, let's talk a little bit about those questions. What is school for? Who is it for? And who gets to decide?
Right, yeah, because if this is a sea change, we need to know those waters. We need to know where we've been, where we're going. So let's start with that first question. What is school for? Well, public education in the United States, that has been a perennial conflict. It's for a lot of things. We ask our schools to do so much. Right. And for its part, the law has always embraced multiple valid educational goals.
Right.
So looking at classic Supreme Court cases like Brown versus Board of Education, the court said that we rely on public education to prepare students for democratic citizenship, to prepare them to be productive members of society, the economy, to awaken cultural values. And a lot of those values and goals are very individualistic. They're focused on developing the individual, but they're also collective in really important ways because they're helping us build a better, more just, equitable society. And so the court has kind of always said, education does a lot of things, but looking at those kind of communal goals as being very, very, very important.
Right. Okay, so if that's kind of where the law started with all of this, where is the law going with this with respect to that question about what is school for?
Right. So if we started with the collective goals, you might anticipate where we're going. Individualistic goals, right? So this all started in the 1950s when some economists started rolling out the idea of education vouchers. And we saw this shifting understanding of schools not as being a collective good, but as being something that is an individual consumer good. It's something that individuals use to advance their own self-interest rather than something that we as a society do together to improve all of our lives. And while it might have been going back to the 1950s, the courts have kind of supercharged this shift, and state legislatures as well. So we've seen
lately,
charter schools, voucher programs, education savings accounts, a lot of things to kind of privatize schooling, to create educational options. And the Supreme Court got into the mix too with Mahmoud versus Taylor, recent Supreme Court case.
The parental rights stuff. Right?
Yeah, that was parents challenging the inclusion of LGBT plus books and said, exposing my children to that violates my First Amendment rights. Yeah. And the court sided with them and recognized a parental opt-out from the curriculum. And then there's also the Oklahoma religious charter school case where Oklahoma would have been the first state to allow a public religious school. And so both of those examples are kind of examples of parents and communities using education in ways to avoid pluralism, these collective goals, and instead teaching only one view or idea or set of ideas.
Yeah, so and that Mahmoud case and the Oklahoma case are great examples of these cases, the courts kind of saying, students have to learn this, and we can't expose them to those different ideas. And so, it definitely makes it obvious that they are focusing a lot more on pushing that school for the individual good as opposed to the collective good.
Yeah. And I've been trying to think of a good metaphor for this. So let me know what you think of this. It's the difference between ordering a pizza and going to a buffet.
Okay, explain.
It's not self-explanatory?
No.
So ordering a pizza, like we've all been in a big group ordering a pizza, right? You got to figure out, all right, how many pizzas are we going to get? What toppings are we going to get? Someone's a vegetarian. Someone's allergic to mushrooms. Someone says absolutely no to olives. And so you work together, you figure it out, and you order the pizzas, and you all share, right? That's the collective view of education. We all work together to provide an education, then you kind of, choose from amongst those options.
In my house, everybody just ends up getting angry with one another, and they walk to their corners and don't talk.
That's why you get, the cheese pizza and the pepperoni pizza, right? Or if you're my kids, just the cheesy bread.
Right.
No vegetables allowed.
All right, well, we're going to work on that metaphor.
I think it's pretty good.
Okay.
But the buffet, you go down the line and you can pick exactly what you want. So that's the individual view of education.
Okay. All right. Well, let's move to the second question. Who is school for?
I'm glad you're asking me easy questions.
Yeah, they're all easy now. Yeah.
So the answer for who is school for, a lot of this comes down to different ways of understanding what we talk about when we talk about equality. This is such a complicated answer because the history of American education, particularly public education, has been around issues of power and those with power excluding or marginalizing or even working to assimilate those without, right? And so we have this very, school has never fulfilled those kind of egalitarian goals that we have for it. That was true up to the 1950s, though with Brown versus Board of Education and the Civil Rights Act and some of these other big civil rights moments, we saw courts kind of adopt the view that separate can never be equal, and so education was more for everyone. But the history of desegregation and the litigation with that kind of showed that that was really an uneven path. And so as this kind of went on, though, courts have narrowed their understanding of what equality means and what discrimination is. And so for the Supreme Court, at least, when thinking about the Constitution and its Equal Protection Clause, anti-discrimination, they require the discrimination to be intentional. It has to be based on a desire to treat people differently. And that's different than looking at the impact of laws. And so the court has kind of narrowed those ideas about what constitutes discrimination, and that is even before the shift we're going to talk about now.
Yeah. So, so there's that, we've talked a lot about equity versus equality and all of that stuff. So it kind of goes back to, I'm sure everybody's seen that cartoon with the kids of different heights and they're trying to look over the fence, right? And so they have the boxes to help them do that.
Yeah, so they're all watching the baseball game?
Right.
Yeah.
So the version of equality that those cartoons usually show is that kind of strict equality where everybody gets the same thing regardless of need. Everybody's getting that same number of boxes.
Right.
Equity, on the other hand, is when everybody gets what they need to see over the fence, right?
Right. And the law, for all its faults, has adopted a version that's more in line with that understanding of equity.
Right.
So you have to treat people the same unless there's a valid reason to treat them differently based on some, relevant characteristic. And as long as there was that kind of substantial justification, you could provide more equitable solutions.
Right. And so, one example is there was a case from the 1970s, Lau versus Nichols, and there were Chinese students in the San Francisco Bay Area. There were thousands of them, and none of them could speak English. And the case went all the way to the Supreme Court, and the argument that the school district was making in that case was the idea of equality, right? Hey, we've not done nothing wrong. We've given everybody the same textbooks. We've given everybody the same teachers. They're all in the same classes, and that was the argument that the school district was making at the Supreme Court. And the Supreme Court said, "Yeah, that ain't good enough."
No,
right?
Thank you.
And that was the Supreme Court jumping onto an idea that Chris was just talking about, is if there's enough of a difference in that particular group that we need to actually do something, treat that group differently because we have a really important reason to do so, then it's okay to do that.
Right. And affirmative action is a fantastic example of, where we've been and where we've gone.
Yeah.
So with affirmative action in the early 2000s, the Supreme Court said, affirmative action is okay constitutionally because schools have a compelling interest in creating a diverse student body, a diverse learning environment. And in order to do that, you have to take into account diversity, including racial diversity. Right. And so there you had a relevant difference. It was substantially related to this goal of compelling diversity.
Right. There's an important reason to do this.
Exactly.
Yeah.
But a few years ago, with the Students for Fair Admissions case, the Supreme Court struck down race-conscious admission policies, basically saying that discriminating based on race or even considering race was itself discrimination based on race for other groups, like in that case, white students and Asian American students.
Yeah. So it's definitely, there's definitely been a shift there, right?
Right, and it's gone even farther with the Trump administration. So the Trump administration has kind of taken the view that awareness of inequalities is itself evidence of racial discrimination. So this idea that because you did something to remediate racial inequality, you are motivated by race, which then makes it racially discriminatory. So the Trump administration has kind of taken that logic to an extreme.
So I guess one way that we kind of envision this is going back to that cartoon with the fence and the boxes. It sounds like where we're at now, there's a third panel in that cartoon and there's no boxes at all, because to have boxes would mean to acknowledge that there are kids of different heights.
Right.
And acknowledging that there are kids of different heights is
discriminatory based on height.
Yeah. Based on height.
Right, yeah. And so, in that view, you couldn't even give out the boxes because that would acknowledge existing inequalities. Right. So this essentially creates like a constitutional status quo. It turns civil rights law on its head. It turns the equal protection clause into the unequal protection clause.
Right, right. All right, well, let's go to the third question, and let's talk a little bit about who gets to decide. Right. So we already alluded to this one with your elegant pizza metaphor.
It's workshopping.
But if we're moving away from democratic governance, that means we're moving more towards this individual consumerism of education, and education becomes a product that kind of people can buy for themselves rather than this collective good that we've all shared a stake in. So who gets to decide? Who's making these decisions?
Right. And that's been a perennial struggle in education law, is who gets to make decisions for students and for schools. And the consensus answer had been this idea of local control. We want local communities to be in control of local schools through democratically elected school boards, PTAs, whatever it might be. Right. That had been the rule, though, with an important caveat that obviously state law could oversee local control, and then also important federal protections around like federal rights and things like that that guaranteed educational equality. But we've seen that shifting in at least three different ways. We've seen the federal government retreat from school governance by trying to close the Department of Education and getting kind of out of the education game. We've seen states really engage in a lot of like micromanaging of schools, going so far as like plucking books out of the library. Right. And then parents are on the other side of this, and parental rights have been used as kind of a claim to override the democratically enacted school decisions. And so schools are kind of getting it from a lot of different directions.
Yeah, it kind of reminds. I'm really dating myself here, but it kind of reminds me of the Stretch Armstrong character.
Yeah, no.
And you,
I know Stretch Armstrong.
Thank you. Schools are just being pulled in all these different directions by all these different constituents, right?
Right. Yeah. And I think the best example of this shift are, we're all probably aware of like the anti-CRT laws.
Right.
The inappropriate materials laws, things like that were really prescriptive from states about like what could or couldn't be in the curriculum, what parents or what students could or couldn't say. Like, that's very, very deep in the weeds of what's happening in schools. And then Mahmoud, again, the Mahmoud decision recognizing parental rights, we have these parents who are opting students out of particular aspects of the democratically enacted curriculum. So it basically transforms schools and school choice into this like within school veto power, at least as it relates to individual students.
Yeah. Yeah. Well, listen, I promise we're going to end on a happier note than what it sounds like right now.
There's just a lot going on.
There's a lot. It's just, like you said, it's like we're drinking from the fire hose. But that is where we are, and those are the waters that we're trying to navigate. But it's important to kind of recognize with all of this, it's important to recognize that none of this stuff just happened, right? People fought for those answers and for those shifts, and they fought hard. And what we're living through right now is another fight. It's a deliberate, strategic effort to relitigate a lot of those answers that we thought had been pretty well established. Right. So it's not just political winds changing. It's lots of laws and cases that are making these headlines, and those things were carefully chosen. They were carefully argued, and they were aimed at a very specific target. So someone, or a lot of someones, decided that they didn't like where the law had settled, so they got to work. And it's working. Lines that seemed settled are moving. Protections that seemed secure are being tested. And by the time most people notice, a lot of that foundation has already shifted, right?
Right, and we're in the middle of that right now. But like we said, we're drinking from the fire hose, but it's important to remember that the old answers didn't just happen either.
Exactly.
Right? The old answers were also the result of a lot of concerted effort and strategic choices. So like take Brown versus Board of Education, for example. That was decades of attorneys and civil rights leaders working to overturn Plessy versus Ferguson.
Right.
And so, we're in the middle of this right now. The law has never been neutral. It's always been a source of conflict. We often say that the arc of justice is long and can bend in different directions, but that also means it can bend back.
It can bend back, exactly. So, despite what it might sound like, it's not. We're not going to end on it's all doom and gloom and let's just throw in the towel. It's a good thing to remember that, especially when it feels like that all that the law is doing is working against you, remember that the law isn't a one-way street. The same legal system that's telling Louisiana that it's okay to post the 10 Commandments in its classrooms, that's the exact same legal system that told Oklahoma's State Board of Education that it cannot force a school system to pull the Kite Runner and the Glass Castle from their bookshelves. That was the case that Chris alluded to earlier.
Right.
So that was the case. The state had ordered the books removed, threatened to strip the district's accreditation if it didn't comply. The governor got on board. And so, that was a big deal. And the school system, the Edmond School District, said, back off, that's not your call. I think they said it nicer.
No, that's how lawyers talk.
So they said the law doesn't give you the authority to do that. That's our job. That's our authority. And the Oklahoma Supreme Court agreed. Every single justice.
Right, and that wasn't luck, right? That was a school district that understood the law well enough to use it for themselves, right? They didn't panic. They didn't tuck their tail in. They didn't just comply or to take those 2 books. And, it'd be so easy to just take 2 books out of the library.
Right.
But they knew the law. They pushed it. They filed suit, and they won.
And the silly thing is, we hear stories of this all the time across the country. We hear somebody gets upset, and so the superintendent just pulls all the books.
Right.
But you don't have to in many cases.
Right.
Know the law.
Yeah.
Yeah. So that's kind of what gives me a little comfort here. The law is a tool. And right now, a lot of people who understand that are trying to use it. And they're using it pretty effectively. The big question is whether or not the rest of us can use it too. So what does that actually look like? What does it mean to use the law or to work within it when you're not an academic or a lawyer? What does it mean for the ones who are really doing the hard work on a daily basis? What can we do about all of this?
Right, and that's the key question. Naming what's happening and understanding it is a fantastic first step.
Right.
But to me, it kind of goes beyond that. I often joke that the law is too important to leave to lawyers, which good for you, Jamie.
Yeah.
But we need to know the law, and more importantly, we need to know how it works and how we can use it and work through the law to pursue our own goals. And to me, that's what legal literacy is. It's the ability to kind of be empowered to use the law as a tool to understand it, understand where the gray areas are, where there's play in the joints, or where you can, use it as a sword or a shield to advance your own interests.
Right. And that's what I tell my students who are aspiring school leaders all the time. Legal literacy doesn't mean going to law school. Nobody's asking teachers and administrators to become lawyers. Legal literacy is about developing informed habits, not just expertise. So we kind of came up with 4 habits that we think can help all of us become a little bit more legally literate. And the first one is to dig a little deeper. pay attention to the questions behind the headlines. The news will say something about a book ban or trans athletes or a coach praying on the field. But the courts and the laws aren't often answering those specific questions. They're wrestling with the legal underpinnings that can inform the answers. So look for who is exercising the authority here, what's the constitutional question, whose rights are being implicated, and if you can identify those things, then you're halfway there to understanding the legal issues, right?
Right. And speaking of headlines, the second one, don't assume that the headlines or the loudest voices accurately reflect what the law says or does. Because so often we'll see the big splashy headline, it'll say, you can't talk about race in schools, right?
Right.
But then you read the law, and that's not what the law does. The law is so much more nuanced than that. There's always going to be shades of gray. It's never black and white.
Right.
And, when we see these big headlines, we often think oh, well, that settles that. I just need to comply.
Right.
But, it's a lot more complicated than that. Like your Oklahoma book example makes clear, right? That was powerful. It seemed done. But even if the rule was crystal clear, which it wasn't, they didn't have the authority to do it on the back end. So there's other legal authorities at play there too. So when you're looking at this stuff, it's important to ask, what does this actually say? Has a court ruled on this? Are there other legal issues that I need to think about that could affect how this is interpreted or applied? Is there room for interpretation or discretion? How is it enforced? All of those things come into what the law actually looks like in practice. And in education, I know I've felt this both as a teacher and as a school attorney. We tend to be pretty risk adverse because we want to do what's best for kiddos. And, in order to do that, we need to make sure. Right, yeah. And so playing in that gray area is really tough.
It's hard.
That's
But there is gray area.
There is gray area.
Yeah,
exactly.
Yeah. So here, and the third habit is, while we're not asking anyone to become a lawyer, knowing more about the law is what gives us the ability to ask better questions, right? We don't want folks to memorize case names or legal doctrines. Instead, we want folks to find some trusted sources that will help you translate the silly legalese. Sorry, Chris.
Some offense taken.
You need because it needs to be translated into something you can understand. And this stuff is hard. Look, I'm not a lawyer, but it's not going to happen. My wife would kill me. I've made this stuff my main focus for the last 5 or 6 years, and I still struggle with it. So it's important. Make friends with a lawyer. I promise you, some of them are actually pretty nice.
Okay. Offense untaken.
No, but look for some good places that translate this stuff into accessible and actionable information. EdWeek is a great news source for this. The Education Law Association that Chris and I are both affiliated with is another great source. They just started putting out a brand new practitioner-focused magazine. We've got some up here for you all to pick up on your way out. We've got some resources on our website that are great resources to help educators kind of understand what's happening with the law. And there's also, there might be a podcast out there you could follow.
Oh yeah, which one? Shameless plug. I like it. But the last habit kind of combines all three. And it's important thinking about this to start thinking about how we can do this together.
Right.
So starting to talk to those in our organizations, our professional networks, and turning those first three habits into conversations. And hopefully that shifts kind of the conversation from stressing out about these laws to strategizing about what can we do to work through these laws or to even use the law to advance our own kind of collective interests.
Yeah. So those are the 4 things. Look for the legal questions, don't confuse rhetoric with the law, and find some good information sources, and then talk about it. All right? That will start to get us step by step a little closer to being the change that we want to see, pardon the cliche. And remember, legal literacy doesn't mean knowing all the answers. It means recognizing when the law matters before you make the decisions. It means knowing enough to ask the right questions.